Welcome and good morning, everyone. My name is McKercher Lecture, and I'm the chair of the Speakers Committee at the University of Saskatchewan's College of Law. And I'm pleased to welcome all of you participating live and those of you who will be watching this recording after the fact. Pleased to welcome you to this being our last speaker event of the term as part of the McKercher LLP Lecture Series. As we gather virtually today, I acknowledge that I'm on Treaty 6 territory and homeland of the Métis, and we pay respect to the First Nation and Métis ancestors of this place, and we reaffirm our relationship with one another. This edition of the lecture series is being presented entirely online, as all of our events have been this fall. While we haven't been able to gather in a physical space, we've remained committed to delivering a wide range of informative and educational speakers and events to our broader law school community. And we think even further beyond this year because of the online venue. As always, we thank the McKercher Law Firm for their continued support of this lecture series.
McKercher LLP has had the privilege of being a proud supporter of this lecture series since its start in 2014. The decision to support the College of Law in these lectures was an easy one for us, as we understand firsthand the great job that the college does in educating and preparing successful lawyers. Education, knowledge, and innovation are crucial in securing the future success of our province. Our support for this initiative provides a catalyst for provoking thought, enhancing collaboration, and engaging future leaders. With the transition of these lectures to the virtual format, we hope that this will provide an even greater opportunity for the College of Law to enlighten and engage students, lawyers, in our community on these important topics. Stay safe, be well, and enjoy.
Before we get started, I'd like to go over a few of the standard online housekeeping items. So as I mentioned, this presentation is being recorded and it will be available online afterwards. We, as always, remind you to keep your microphones on mute during the presentation and your videos off, since that, aside from the panel, since that allows the event to proceed a little bit more smoothly. Depending on what device you're joining us with, there is usually an option to select speaker view over gallery view. We will be using a PowerPoint presentation during much of this event. The panel is going to be followed by a Q&A session, and we're going to ask that if you have questions that come to you at any point during the event, during the presentations or after, that you type those questions into the chat. And we will monitor the chat, and our moderator, who I'm going to introduce in a moment, will relay the questions to the panel in the question period that will follow. If you have any technical issues that come up, please comment in the chat, and one of our College of Law staff will do their best to assist you. So let me take a moment to introduce our moderator today. Our moderator is Madam Justice Georgina Jackson. And in giving her a very, very brief introduction, I'm going to mention a few things that you may or may not know about Justice Jackson. I want to start by saying that her friends and colleagues in the legal community consider her to be a trailblazer since she graduated from our college in 1976. After serving as a partner at McPherson, Leslie & Tarman, she was appointed to the Saskatchewan Court of Appeal in 1991, one of the youngest people ever to be named to that court. She's also served as Saskatchewan's Master of Titles, overseeing the provincial land registration system. She continues to offer important leadership on so many matters across the field, and we're very grateful to have her leading the charge on our panel today. So I'll now pass things over to Justice Jackson to introduce the rest of the panelists.
Thank you, Professor Keat. Good morning, everyone. I'm very pleased to moderate this panel. The area of insolvency and secure transactions law has been one of great interest to me throughout my career. Now, you will see the title of the seminar is Insolvency, and the CCAA in 2020, Practical Developments and Tips for Legal Advisors. There could be many other titles for this seminar, and I was thinking that in some respects, a better title would have been Negotiating Corporate Settlements Within the Framework of Insolvency Legislation. And why do I say this? All insolvency work is guided in some way by four main pieces of legislation. The first act of course, is the Bankruptcy and Insolvency Act, known as the BIA, and we will be calling it that during this seminar, the BIA. The second is the Companies Creditors Arrangement Act, known as the CCAA, notwithstanding its rather peculiar title. This piece of federal legislation is a significant one against which much of the work in the area of insolvency first gained some power within the last 20, 30 years or so. And the third is the Personal Property Security Act, or the PPSA, and of course the Queen's Bench Act, known as the QB Act, with these latter two acts being instrumental with respect to the appointment of receivers. Now, what is so interesting about these acts is, and for this seminar today, is that you're not going to hear too much about the actual provisions of those acts. We won't be citing sections, or for the most part, not citing sections of these acts. And that's because, as our panelists will demonstrate very well, all of this statute law provides the framework for a lot of deep work that depends on the skills and expertise and experience of the lawyers who negotiate insolvency settlements. And they negotiate within that framework of the law, which is why I spoke of an alternate title. So our three panelists today give us the rare opportunity to see how statute law, rules of procedure, and case law shape how business functions. Our first speaker is Mr. Jeff Lee, QC. Mr. Lee is a partner with MLT Aikins LLP. He represents companies in financial distress, lenders, and court officers in restructuring and insolvency proceedings across Canada. He's going to talk to us at an overview level, the nature of restructuring, and to be clear, we're talking about corporations in this seminar, the statutory framework, recent CCAA and BIA proceedings in Saskatchewan, and he will reinforce this point that I've made, that much of the settlement takes place without the assistance of the court, but takes place within the framework of the law. Our next speaker will be Ms. Janine Lavoie-Harding. Ms. Lavoie-Harding is a partner in the Saskatoon office of McKercher LLP. She advises and represents debtors and creditors in restructuring and insolvency proceedings, as well as clients in commercial litigation matters. Now, Ms. Lavoie-Harding is going to take a fact pattern, which she will explain, and from there she will develop her thesis and theories about what typically happens from the perspective of a debtor when a lawyer gets the call from a corporation that's in financial distress. Our third speaker is Mr. Michael W. Milani, QC. Mr. Milani is a partner with McDougall Gauley LLP in Regina. He has a varied commercial practice with a particular emphasis on banking law, secured transactions, insolvency, and financial restructuring, including litigation related to those matters. He's also a member of the firm's executive committee. Now, Mr. Milani will pick up the fact pattern that Ms. Lavoie-Harding will have introduced, and he will work through what typically happens, but now from the perspective of the lender. So he will explain what happens when the call comes in from a lender indicating that the lender's client, a corporation, is in financial distress. So each of our speakers will speak about 15 to 20 minutes. We hope to leave time for questions. As Professor Keat has indicated, you can put your questions in the chat room. And with that, I thank the college, Professor Keat and Ms. Richard, and it's now over to you, Mr. Lee. Thank you.
Thank you, Justice Jackson, and good morning all. Thank you for the opportunity to speak to you today. Our focus today is on practical developments and tips for legal advisors in regard to insolvency, restructuring, and the CCAA. The items that I will address today will comprise 5 matters. First, we'll identify the 3 major restructuring platforms used by insolvent companies in Saskatchewan. Second, we'll review the similarities and differences between those 3 platforms. A third point will be to identify the factors determining which platform is chosen. How does that happen? Fourth, we'll talk about the common goal pursued by participants and stakeholders in restructuring. And then as a 5th item, we'll look at the data on how these platforms have been used in regard to insolvent companies in Saskatchewan over the past 10 or 12 years. So the slide on the screen now notes the 3 main restructuring platforms we'll discuss. The first of those is the CCAA, which Justice Jackson described. That was a federal statute enacted at the height of the Great Depression in 1936. It was little used for the most part throughout a good part of the 20th century, but beginning in the 1980s and 90s became used fairly extensively. And that has resulted in a couple of significant rounds of amendments and enhancements to that statute in 1997 and 2009. And that'll be our first platform for discussion. Second, we'll discuss a particular section or part of the BIA that Justice Jackson referenced, and that is Part 3, Division 1. That regime was introduced into federal law in 1992, and it contemplates debtors making proposals to creditors, or at least filing notices of intention to make a proposal to creditors. We'll call those NOI proceedings, and those will be our second main platform. And then the third platform we'll discuss will be receiverships. Receivership as a remedy has existed under provincial law for many years. Justice Jackson mentioned the PPSA and the QB Act. Those are sources of jurisdiction for this remedy. The primary one of import for us to discuss will be the National Receivership Remedy in Section 243 of the BIA. That was introduced into federal law in 2009. If we could move to the next slide, please. These platforms share similarities described on this slide. Notably, they all provide for a stay of proceedings, which preserves the status quo, takes us out of the law of the jungle or the race to the swift, and puts us into sort of an orderly status quo regime where parties approach the process under a status quo regime and requires them to cooperate and engage and negotiate outcomes. The second similar feature between all 3 regimes is court supervision. In each case, outcomes are achieved under the supervision and guidance of courts. In Saskatchewan, we have an insolvency panel of the Court of Queen's Bench, and upon occasion that will be addressed by the Court of Appeal as well. Third, we have a transparent flow of information from court officers in each regime. In the CCAA, our court officer is a court-appointed monitor. In NOI proceedings, our court officer is a proposal trustee. And in receivership, our court officer obviously is the receiver. But in each case, they perform a similar information flow function. They prepare reports. They serve as the eyes and ears of creditors in the court. And that's a common feature between all regimes. Fourth feature noted on the slide is financing. Many of the companies that invoke these platforms lack cash flow, do not have abundant financing with which to finance these proceedings. So each of these regimes provides for new money to be brought in to finance the proceeding, secured by a court-ordered first priority charge. In CCAA or NOI proceedings, that's interim financing, and in receivership, it's receivers' borrowings. A few other similarities noted on this slide. Each of these regimes or at least two of them, provide for an administration charge to secure fees of restructuring professionals, and there's a variation of that in the third regime. So the constituencies who benefit from this or whose fees are secured include debtor company counsel, the court officer itself, and legal counsel to the court officer. It's self-evident that companies in need of the regimes don't have abundant cash flow, can't always guarantee payment of fees, so the regimes allow professionals to take these mandates with some comfort they'll be paid for their work. It's also noted that the supervising court can approve the sale of the debtor company's assets outside the ordinary course of business in each such regime. And then finally, we are guided in this practice area by template orders developed by the Provincial Insolvency Bench and the Provincial Insolvency Bar. There are template orders that guide us under CCAA receivership, and the NOI proceedings as well are modeled on these. So if we can go to the next slide, we'll identify some differences. How are these three platforms different? Well, two of them are debtor in possession proceedings. When companies restructure under the CCAA or the NOI proceedings, the existing management remains on board and in control. Subject to certain limited exceptions, the usual regime here is existing management stays in the chair and guides the process. And that's not the case in receivership. When a court order goes appointing a receiver, the legal effect of that is to oust the power of the board of directors and trigger a change of control where key decisions will now be made by someone other than management, by an independent receiver. NOI proceedings, the slide notes, those are commenced without a court appearance. That's a unique feature. To invoke an NOI proceeding, a debtor company simply completes a statutory form, satisfies certain statutory requirements, and need not appear in court in first instance. The slide also notes that NOI proceedings are subject to a maximum prescribed length or duration. That's the initial 30 days plus 6 months. A couple of other differences noted on this slide. NOI proceedings are unique in that they have two possible outcomes and two possible outcomes only, either a successful proposal or a deemed assignment in bankruptcy. The debtor company invoking the NOI proceeding cannot think better of it on day two and say never mind and withdraw the proceeding. It's on an irrevocable path to one of those two outcomes, one of which is deemed assignment in bankruptcy. NOI proceedings are less costly, and it's noted that the CCAA proceedings allow for greater flexibility. And so how is the choice of platform made? Well, this next slide identifies a key factor, and that is timely access to professional advice. Early access to professional advice provides for more and better restructuring options, and it is a reality that lenders enjoy timely access to professional advice. They deploy staffs of special account managers to manage these things. These are people who do nothing but manage troubled accounts. They know the playing field, they have experience and expertise, and they have access to professional advice. And that gives them better planning opportunities and greater control over the outcome. That is a reality. Debtor companies, however, can counteract that if they obtain timely professional advice. If they consult professionals in the area early, their options are better. Where they're proactive, a file that might wind up in receivership, if it simply drifts along, could be put into a CCAA or NOI filing driven by the debtor if the debtor acts promptly and obtains early advice. Access to funding is a similar feature that will determine the choice of outcome. Obviously, banks and creditors have superior access to funding as a general rule. But once again, debtors who act early and obtain timely advice can counteract that, can unlock liquidity in their assets through interim financing. Or the third bullet point notes that key customer relationships can sometimes be a source of support. I'm reminded of a Saskatchewan agribusiness insolvency about 6-7 years ago that hit the wall with its existing bank, who was not prepared to fund a proceeding, but realized it had one or two key customers in Europe who relied heavily for the supply of product to stay in business, and they were more than happy to support the process and allow the distressed Saskatchewan agribusiness to attempt restructuring by lending interim financing into the process. We could go to the next slide. This slide notes that preserving value is the common goal. Regardless of which platform we're in, all stakeholders share the goal of preserving and enhancing value. The strategies invoked to pursue that outcome are noted on the slide. They include interim financing, which we've already discussed. A sales and investment solicitation process is a typical strategy. It can be used to attract potential equity investment or acquisition interest. And of course, the compromise of unsecured debts to clean up the balance sheet is another potential strategy often employed. A couple final notes in this area. Justice Jackson mentioned negotiation, and it bears repeating that successful restructuring is more often achieved through negotiation than it is through litigation. Collaboration among stakeholders will drive a consensual outcome, which will assist in preserving value and enhance a certainty of outcome. Communication is key. Building trust and credibility is important. Much of the work occurs before court. You can move to the next slide. It's noted here that it's not necessarily the case that stakeholders regard the opposing professionals as adversaries. If the professional across the table has a track record and experience, they can be a source of comfort and increase the comfort level and help facilitate compromise. And again, just to reiterate, the goal is to resolve differences before court. Leaving contentious, significant matters to be argued in court is generally regarded as a shortcoming or a failure in this practice area. So we'll move to the next slide and look at the data. What does the data tell us about how these platforms are used in this jurisdiction? Well, there's data publicly available for our purposes going back to 2009, which was the last round of amendments. We noted from the data that 62 Saskatchewan corporations invoked restructuring over this time frame. By far and away, their most common restructuring outcome was the sale of assets as a going concern, where the business continues to operate and is sold as an organic enterprise with enterprise value rather than just sort of a breakup auction approach. By far and away, the most common platform was receiverships. We had 40 such enterprises be restructured through the receivership platform, 12 through NOI proceedings, and 10 through CCAA. 7 in our local courts, and for reasons best known to them, 3 Saskatchewan companies restructured in other courts from other jurisdictions. Over the past 12 years, we've averaged 5 major commercial insolvencies a year in this jurisdiction. Over the past 5 years, we've averaged 8 per year. The slide notes a couple of identifiable peaks in there, with commercial hog production going through significant insolvency activity in 2012, and oil and gas going through significant insolvency activity by our standards in 2017. And over the 12-year period, oil and gas was most frequently represented in restructurings in Saskatchewan, real estate as well, 10 and 9 respectively. Construction accounted for 8 insolvencies. We mentioned commercial hog production, which accounted for 5 insolvencies over this time period. Hotel hospitality and grain handling accounted for 5 insolvencies, and manufacturing accounted for 4 of them. Then this year, in Saskatchewan this year, we have tracked or identified 8 significant commercial insolvencies, 5 through receiverships, 2 through NOI proceedings, and 1 through CCAA. And the particular sectors involved are noted on the slide: construction, manufacturing, hotel, real estate, and fitness. Moving to the next slide, we'll finish up my segment by just taking you through the 7 filings under the CCAA in Saskatchewan over the past 12 years. Again, we're a mid-market jurisdiction. The CCAA statute is legally available only to enterprises that owe $5 million worth of debt or more. By definition, that is a limited pool in a mid-market jurisdiction like Saskatchewan. And then by definition, further definition, those who actually obtain advice early enough to invoke the process are still more limited. But there have been 7 of them, beginning with Clayton Construction, Northwestern Saskatchewan in 2009, invoked the process in owing secured debt of around $12 million. One of the largest in Saskatchewan was Big Sky Farms from 2009. It operated from 32 facilities in Saskatchewan and Manitoba, as well as Iowa and South Dakota, and owed secured debt of about $115 to $120 million. Also noted on the slide, Advanced Engineered Products out of Regina. It manufactures those tanks we see on the back of petroleum trucks driving around Western Canada highways. It restructured in 2015, owing secured debts of about $115 to $120 million. The fourth restructuring noted was the Ore Center, Regina and Saskatoon in 2016. Moving to the next slide. Copper Sands Land Corp, a trailer park mobile home facility with a water treatment utility out of Regina in 2017. We had Colesy Homes in 2018 in the real estate sector. And finally, Morris Industries, an ongoing in Saskatchewan. It operated in 4 or 5 locations in Saskatchewan and Manitoba, and it filed for CCAA in January of 2020. Those will conclude my remarks. I'd like to thank Shay Brame, student at law, for assistance on the research. And I think next we'll hear from Janine.
Thank you, Jeff. And good afternoon, all, and thank you for having me here today. Mike Milani and I have prepared an example of a real-life scenario in order to discuss what will typically occur when advising clients, either from the perspective of advising the debtor or the lendor, when faced with a business that is in financial distress. I will be speaking from the perspective of acting for the debtor. The scenario that we have developed is this. The debtor, Kathy's Boutique, owns a clothing store located in a shopping mall in Yorkton, Saskatchewan, specializing in Canadian-made blue jeans. The blue jeans are supplied by a Winnipeg manufacturer called Jean World. The debtor purchased the business a few years ago. The former owner, Mr. Ajit, retained a small interest in the business, but is not actively involved. The owner of the mall, Yorkton Mall, is the debtor's landlord. The debtor owes money to a bank called the Parkland Bank. Receiving that initial telephone call from the client. When acting for a debtor, typically the reasons for receiving that initial call will be such that an initiating event has occurred, whether a demand has been served on the debtor by a stakeholder, or if the situation has significantly deteriorated, court materials have been served on the debtor. During that initial call, you will want to ascertain from the principal of Kathy's Boutique, with as much detail as possible, the individuals and entities involved, including the names of the individuals who are principals of the company, if the debtor is a company, as well as the name of all stakeholders. This information needs to be obtained without obtaining any confidential information about the circumstances of the matter. You will then need to conduct an internal conflicts check within your firm. Given that usually an initiating event has already occurred with respect to the debtor's business, there is typically some urgency to complete a timely conflicts check and respond back to the proposed clients. Now, assuming the conflicts check is clear, you will then want to meet, usually in this day and age by video conference or telephone, with the principals of Kathy's Boutique to discuss the current situation with the debtor. It is my practice, if the client is not one of the firms already that I know, I spend a good portion of that time on the second meeting trying to understand the nature of the business, and in this situation, Kathy's Boutique. During pre-COVID times, I would try and even attend at the client's business in order to gain a better understanding of the type of business the debtor operates. This practical, boots on the ground information I have found will serve you well throughout the life of the file. You will then want to know whether the debtor is a corporation, a partnership, or some other entity. Finally, you will also want to know what the debtor's ultimate goals are, whether Kathy's Boutique believes there is a chance to preserve the business enterprise, or whether Kathy's Boutique is looking to wind down the business and proceed to liquidate. I typically say to a client on this initial call, what is a good day for you at the end of this? Or where do you want to see this process going? You will then want to know who the primary stakeholders are and what knowledge do they have of the current issues facing Kathy's Boutique. In this scenario, the stakeholders will likely be Parkland Bank, Gene World, the Yorkton Mall, Mr. Ajit, if Mr. Ajit signed a personal guarantee, and the employees of Kathy's Boutique. You will also want to know what position these primary stakeholders are taking in order to assess the urgency of the situation. Finally, and most importantly, from my perspective, is asking whether the debtor knows which legal counsel is acting for the primary stakeholders. As Jeff has discussed, timely involvement of respected insolvency practitioners can increase comfort levels among opposing parties and facilitate compromises, which, when acting for a debtor, is absolutely critical. Next, you will want to understand the loans and the lease. Each loan will be different, with different security that has been provided to secure the debt. You will also want to know if any personal or corporate guarantees have been given by third parties to the lender. This is critical as this information may impact the ultimate strategy you recommend to the client when dealing with the client's debt situation. In this situation, it may be that Mr. Ajit, as former owner of Kathy's Boutique, gave a personal guarantee, guaranteeing the debt, which has not yet been released by Parkland Bank. So this is something to think about and address. In this scenario, there will also be a lease with the Yorkton Mall. You will want to know in broad strokes what that lease arrangement entails, such as the term of the lease and when it expires, and whether any personal or corporate guarantees were given as it relates to that lease. Again, this may be a situation where Mr. Ajit, as former owner of Kathy's Boutique, gave a personal guarantee, guaranteeing the covenants of Kathy's Boutique as it relates to the lease, as well as Kathy herself may have given a similar guarantee. You will also want to know whether there are any rental arrears. This will also give you a sense of the urgency of the situation in terms of what actions, if any, Yorkton Mall can take. Coupled with that, you will want to know if the Yorkton Mall has threatened any legal action. In some situations, you will find that the debtor has a good working relationship with the landlord if the debtor has remained in regular contact with the landlord. What you find in situations where the landlord has already threatened action is a situation where the debtor has refused to respond to the landlord or the debtor has effectively gone silent. Those kinds of situations typically become more challenging to deal with as legal counsel. Also, in the spring of this year, we also had to deal with the issue of special COVID-19 relief rules as it relates to landlord and tenant. On June 5th, 2020, the province of Saskatchewan announced that it was implementing an order under Section 18 of the Emergency Planning Act to provide commercial eviction protection for small businesses impacted by the COVID-19 pandemic. The moratorium on evictions was targeted towards landlords that chose not to apply to the Canadian Emergency Commercial Rent Assistance Program. So in this scenario, you will also want to ask whether the Yorkton Mall participated in that program as it relates to Kathy's Boutique. Next, you will want to know the status of the lending arrangement. The critical point is whether the loans are term loans or demand loans. If it is a demand loan, the situation becomes more urgent as the repayment of the loan can be demanded on at any time, even on short notice. You will also want to know if Kathy's Boutique has breached the obligations owing to Parkland Bank or the Yorkton Mall. Kathy's Boutique may be in breach of covenants other than non-payment of rent, such as abandoning the premises or selling or disposing of the property of the debtor. You will also want to know whether the debtor has received any demands from the lendor or the landlord. There are certain statutory notices pursuant to the BIA that must be served by a secured creditor on a debtor before it can enforce its security. Therefore, it is important to know whether those notices have been served on the debtor and whether they were served properly. This again will dictate the urgency of the situation for Kathy's Boutique. Once your initial call or meeting has been completed, you will ask Kathy's Boutique to gather and send you copies of all the lending, security, and lease agreements, including any personal or corporate guarantees that have been granted. In addition, it is my practice when acting for the debtor to ask the debtor to provide a list of the creditors and the amounts that they are owed. In representing a debtor, typically you will recommend a plan or path forward that attempts to address all the indebtedness owing to all stakeholders, not just the Parkland Bank and the Yorkton Mall. Finally, you will also want to obtain certain public searches, being a Saskatchewan Personal Property Registry search and a Judgment Registry search to complete a full picture of the creditors of Kathy's Boutique. Next, working with the lender. Again, you will want to know, generally speaking, what is the status of the working relationship with both the lender and the landlord. If the relationships have deteriorated to such an extent that demands have already been served on the debtor, it will be more difficult to facilitate the successful restructuring of the debtor business. When acting for a debtor, it is useful to contact counsel for the landlord and the lender early in the process to start to have constructive discussions. This is something that Jeff pointed to, and I agree with, particularly as it relates to acting for a debtor. If you can get involved early in the process as legal counsel, it will help to resolve matters before having to go to court. Now, understanding the other stakeholders, you will want to know whether there are any unpaid suppliers and what is the status of the inventory. In this situation, you will want to know what is the status of the relationship with Gene World and whether Gene World remains unpaid. On this issue, it will be good to get a list of the inventory that is currently sitting on site at Kathy's Boutique and the inventory that is set to be delivered. Have Kathy's Boutique prepare that list and send it to you, as well as any security agreements that have been entered into with Gene World as it relates to the Gene inventory. Landlords are typically not permitted to seize property that is subject to a purchase money security interest, so it is important to know whether the suppliers have any security agreements. Other stakeholders, including the employees of Kathy's Boutique. You will want to know how many current employees are working for Kathy's Boutique and whether they are part-time or full-time employees. Also critical on this issue is whether the wages of the employees are up to date. You will also want to advise the principals and directors of Kathy's Boutique of certain liabilities of directors as it relates to unpaid wages. Under Section 114 of the Business Corporations Act, directors of a corporation are jointly and severally liable to employees of the corporation for all debts not exceeding 6 months' wages payable to each such employee for services performed for the corporation. So it will be important for the principals and directors of Kathy's Boutique to understand that. Similarly, under Section 2-68 of the Saskatchewan Employment Act, directors of a corporation are also jointly and severally liable to an employee for all wages due and accruing due to the employee not exceeding 6 months' wages while they are directors of the corporation. So again, it'll be important to advise the directors and principals of Kathy's Boutique of those provisions of our provincial statutes. The next stakeholder that may be involved in this situation is Canada Revenue Agency. With respect to CRA, there are certain director liabilities that directors should also be aware of, which you should alert the directors of Kathy's Boutique to. The first is unremitted source deductions. Under the Income Tax Act Canada, it provides that a director may be jointly and severally liable together with the corporation to pay unremitted source deductions. The Income Tax of Saskatchewan contains similar provisions. Also, income tax filings for Kathy's Boutique. Under the Income Tax Act of Canada, it provides that it is an offense to file a false or deception return or in any manner to evade or attempt to evade compliance with the Act or payment of taxes imposed by that Act. Under that Act, it provides that where a corporation is guilty of that, an officer, director, or agent of the corporation who directed or participated in the commission of that offense is party to and guilty of that offense. So that is important to alert Kathy's Boutique as well too. The third is the remittance of GST. And under the Excise Tax Act, the directors of a corporation are also jointly and severally liable together with the corporation to pay the GST owing. And so that is another area of liability that you will want to alert Kathy's Boutique to. The next stakeholder that we'll discuss is the landlord. Under the Saskatchewan Landlord and Tenant Act, and typically contained in the lease, appropriate notices must be served on the tenant for the purposes of re-entry. The landlord must do what it says under the Landlord and Tenant Act, and it also must do what the lease says. And in Saskatchewan, landlords have the right to distrain, meaning seizing and selling property that is owned by the tenant and located on the leased premises. There are two important qualifiers to that right to distrain by the landlord. And that is the landlord can only distrain for rent due and owing at the time of the distraint, and the lease must not be terminated until after the property is leased. So you will want to discuss with Kathy's Boutique whether there is any current rent that is due and owing, and whether the landlord has already given notice to terminate the lease. That will dictate whether or not the landlord has a right to distrain. Finally, we will talk about work options with our client. These options may take a number of different forms, and it'll go back to that initial question that I talked about. Where do you want to be at the end of this process? And Kathy's Boutique, what is a good day for you? One option may be if you can initiate with the stakeholders council early, is a proposed forbearance agreement. And what that is, it's just a plan or agreement between a lender and the borrower to delay the enforcement of security during a specified time period while the borrower makes payments towards the indebtedness, usually on a scheduled payment plan. That may be something that you can canvass with Lenders Council in order to get more time for Kathy's Boutique to restructure its affairs. Now, in our scenario, given that the dollar amounts would not be high enough, as Jeff outlined in his presentation, the option of a CCAA filing will likely not be available. However, another option may also be for Kathy's Boutique to file an NOI under Division 1, Part 3 of the BIA. Again, if you can have a discussion with Kathy's Boutique early on, that option may still be available for Kathy's Boutique. Also, when acting for a debtor, you may have to have that difficult discussion with your client that consenting to a receivership is the best outcome. Consenting to a privately appointed receiver may also be an appropriate option if your client does not believe there is any way to preserve the business operations as a going concern and wishes to limit the costs associated with liquidation. Finally, you will also want to have a discussion with Kathy's Boutique as to whether or not there is an ability to sell the business as a going concern or to obtain refinancing through a lending institution, whether that is Parkland Bank or some other financial institution. The process for refinancing does, in my experience, takes a considerable amount of time. So if this is an option for Kathy's Boutique, you will want to advise Kathy's Boutique to take those steps as soon as possible to commence that process in order to keep that in as an option for restructuring. And that completes my presentation. So I will now turn it over to Mike.
Thanks very much, Janine. So good afternoon, everyone. The scenario that we put forward is a relatively simple one, but all of the concerns and issues that you've heard described so far can actually be applied in a larger scenario, such as a very large insolvency under the CCAA. It will be on a larger scale, but at its core, these same sort of considerations and issues will apply. And as we sort of walk through the example, I'll give some illustrations of how that's so. Just as counsel for the borrower has to be sure of conflicts at an early stage, so too does counsel for the lender. And what we find in acting for lenders is that often the lender's perception of who is involved is more narrow than we are concerned with as lawyers. So for example, the lender may simply say to you that Kathy's Boutique, which in our example is actually a corporation, Kathy's Boutique is just the business name, may be the only person of concern. But as lawyers working in the area, we know that there are going to be shareholders of that corporation, there are going to be guarantors, there may be a landlord involved. And so it's a delicate balance trying to get sufficient information about who may be involved in the piece so that a proper conflict search can be conducted while still not taking in any confidential information, which at this stage can cause real difficulties from a conflict of law, from a conflict perspective. And so going forward, we're presupposing that the conflict search is clear and either that we have no other involvement with any of the other players or that with proper screening devices within the law firm, we can provide advice. So if we go on to the next slide, you'll see that one other interesting piece is that Mr. Ajit is a former owner. And Janine has mentioned that that individual may have provided a guarantee that hasn't yet been released, but he actually will play another role, or may play another role, and we'll come to that a bit later in the discussion this morning. So if we could go to the next slide, please. So the call with the lender, where I often see difficulty is the lenders, as Jeff pointed out, are often very sophisticated. And often they'll reach out to us with a full package of information rather than checking with us first to see if we have a conflict. And in those circumstances, more often than not, I found myself emailing back to the lender saying, I have not reviewed your email in detail. I will call you to determine who is involved. And my view is that although that confidential information has been sent to me, the fact that I have, as a professional, undertook to not review it still does not result in the conflict issue raising its ugly head. And what I mean by that is simply by sending information that isn't reviewed, it should not result in a law firm being conflicted out. So the add-on piece, I guess I would say from a practical perspective, is we can't always control the way in which we get the first contact, and sometimes you have to be react and be careful when you get that email that says more than you want it to. The next slide, please. One of the very important pieces is to determine what the actual lending arrangement is. And so what often happens with a small business is that there is a loan agreement or a credit agreement, but it's usually embodied in a fairly simple letter sent by the lender to the borrower. And that creates the framework of the arrangement. Now, on top of that, there will be security, such as general security agreements, or assignment of book debts, or debentures and guarantees. But it's very important to recognize that the framework really may be set out in a different document. And an example of how that becomes important is, although the standard form security documents are very much lender friendly, allowing things to happen in the lender's discretion, it may well be that under the overarching credit agreement or loan agreement, there are in fact other requirements or restrictions. And so it's important to have all of the pieces in mind. In our example, we are saying that Kathy's boutique is in fact a corporation, but experience is that even sophisticated lenders sometimes aren't focusing on the underlying nature of the entity. And it does make a difference. What you may want to do if the borrower is a corporation may be different than if it's a partnership or if it's an individual, particularly if it's an individual. And the third piece is what sort of business is being conducted. And in a way, you'd think that's sort of obvious. Kathy's boutique sounds like a clothing store, and the lender may describe it as a clothing store. But where lenders and sometimes their lawyers have gotten into a little bit of a problem in Saskatchewan is if the business also has a sideline of farming or agriculture. Because if that's the case, and if it's a material part of the business, then you may find a circumstance in place where all of the notices and protections under the Farm Debt Mediation Act and the Saskatchewan Farm Security Act apply. And the courts in Saskatchewan have taken a very pragmatic view of this. And if the farming business is very much just a very small sideline, I'm growing corn out behind my jean store, probably the protections don't apply. But I would say on a due diligence cautionary basis, exploring all of the types of business being conducted is very prudent to do. Next slide, please. So in terms of the lending itself, often what happens under the loan agreement is there are different loan facilities, and not all of them have the same rules. Some of the loans might be repayable on demand, but some of the loans might have a cure period. And what we mean by that is that if there is a breach of the obligations owed to the lender, it may be that the loan agreement requires the lender to notify the borrower of the default and to give the borrower a specified time to cure the default. What that then leads to in practice is it may actually be necessary to send two notices, one to cure the default and a second one if the cure has not been made during the stipulated period. And where banks can sometimes get themselves and their lawyers into difficulty is by not providing all of the information. Lenders charge ahead and send what would be typical for a demand loan, only later to discover that there was an overarching obligation to provide a cure. So again, that small example reinforces why having all of the information before taking first steps is very important. And so understanding what obligations have actually been breached is of paramount importance. But in addition to that, knowing whether the lender has waived or permitted the breaches is just as relevant, because when a lender is making the decision to go forward, usually they will look back and find all of the things that have not been correct, but by the borrower. But it may be that along the way the lender has waived or permitted those breaches, and if that's happened, then there can no longer be reliance on them. And so once instructions are obtained, there's a number of searches we typically get. Personal Property Registry, Saskatchewan Judgment Registry were mentioned. We also typically get a Bank Act search. Chartered banks in Canada can take a special statutory form of security, and it's just valuable to make sure that in your host of searches that is also done as well. We would typically do a litigation search in the two major Saskatchewan centers, and in our example in Yorkton, of course, because that's where Kathy's boutique is located. Once the lender's files are received by the lawyer, a review is required. And what does that mean? Well, we look for things like that they were actually signed. That's often helpful. The date of the security, and the what I call any gaps in the security. So it may be that either a certain type of security could have been taken but wasn't, or the loan agreement might have provided for a type of security which wasn't in fact given. Sometimes those gaps can be solved by the lawyer his or herself. Sometimes the cooperation of the debtor is required. Sometimes that's covered off in a forbearance agreement. But it's important to know in the as early as possible whether there are any concerns, and that would involve looking at the security files, but of course also looking at the search results obtained to see what in fact has been registered. Next slide, please. So knowing that this is a jean store or a clothing store, there is value of collateral that the lender might have to realize on. And what the lender wants to know at an early date is the wholesale cost of the inventory, the retail potential sale proceeds arising from an ordinary course sale. And maybe an expert is engaged at that time to assess what the value might be. But more importantly, it's determining whether any of the inventory suppliers have priority, and they gain priority through security agreements and having served purchase money security interest notices. And so getting a handle on what's there requires the assistance, of course, of the borrower, but it's more than that. It requires a look from a different perspective as to what that real value may be. Next slide, please. And You'll see that the first note there is how much inventory was recently obtained. And the reason for that is that under some of the laws we've talked about, there's a special priority or a special right for suppliers to get back property that's been recently supplied. And that's if it's in the same state, which really means in the same boxes or cartons it was shipped in. And the second issue falls into the category of potential lender liability. If the lender in some way facilitates the borrower causing a difficulty for inventory suppliers, either by encouraging the borrower to buy more inventory but not pay for it, or dealing with those goods that are still in the boxes, it can potentially cause exposure for the lender. So how those discussions take place takes great care to avoid any concerns. Next slide. Similarly, understanding the employees and the numbers and full or part-time is really important. And where that usually arises, if matters are urgent, there will be a payroll coming due and there won't be sufficient funds in the account to fund the payroll. My experience, and I'm sure that of my colleagues on the panel, is that typically lenders will fund that next payroll while they try to figure out what's occurring, if only because there's two reasons. Payroll and amounts owed to employees take priority over secured creditors generally anyway, but also the lender has an interest in determining if the operation can be saved as a going concern, and keeping the staff is an important part of that. Depending on the size of the entity, determining whether there are pension plans can have a major effect as well. Next slide, please. As Janine mentioned, understanding Canada Revenue Agency's position is important, including because for some of their claims, they will have priority over the lender. There's a document called a requirement to pay that CRA will sometimes serve, and it requires, in my example we're using today, Parkland Bank, to pay to CRA any amounts that Parkland Bank must otherwise pay to the borrower. Now, in this case, there probably won't be any monies to pay because whatever is in the bank account will be set off against the loans that are owed. But again, it's important to understand how if at all, CRA has engaged to date. Similarly, with respect to the landlord, at the start of his presentation, Jeff mentioned that many foot races are gone. Well, one foot race remains, and that's this. If a landlord distrains and completes the distress in terms of seizing and selling goods, the landlord is in a good position. If the distress has not been completed, and if a bankruptcy to occur, the priority position would be reversed, and the landlord would lose to the bank. So often there's early discussion where the potential of a bankruptcy is discussed, and a consensual arrangement is made with the landlord to try to avoid that. Next slide, please. I mentioned before that Mr. Ajit has another potential role. And if the business can be preserved as a going concern, it may well be that the former owner is in the best person to decide whether to re-engage. Perhaps to protect the guarantee he gave, perhaps because he sees it's a good business that just wasn't run that well by Kathy. And so quite often, early engagement where there's a former owner around can occur. Lenders have to be careful with banker-customer confidentiality, but if it's for the legitimate purpose of realizing on the security, there's a fair bit of ambit as to what can be discussed. Next slide, please. It goes without saying that working with the debtor almost always creates the best result. But as a lawyer, we have to remember that we're coming in a little bit later, and there may have been many discussions between the lender and debtor. And often it boils down to trust, the level of trust going both ways. As Jeff and Janine alluded to, experienced counsel can help bridge those trust gaps, and it will always lead to not a worse result, and often, or more often than not, a better result. And as I mentioned before, matters such as the urgency of payroll require early engagement and working with the debtor. Next slide, please. What does the lender want? Well, the lender wants to be repaid, but lenders are businesses within the community, and they have an overarching interest in seeing success of business enterprises. Lenders have a duty to act commercially reasonably. And understanding the debtor's goals and alternatives really is necessary for the lender to understand its own goals. And that's where a professional can come in and be of great assistance. And that relates to things like giving more time to the debtor to pay, having a formal forbearance agreement. Quite often, even though the lender is prepared to be facilitative, the lender wants demand letters and a BI notice to be sent early on so that the lender can move quickly if required. Next slide, please. So what are the realization steps? Formal forbearance agreement buys time and it may lead to something. Maybe it's as simple as a repossession pursuant to the PPSA. Lenders also want to think about whether there's any value in the lease, meaning does Kathy's Boutique have a good arrangement with the landlord? Is there some value there? And in our example, there's not enough for a CCAA filing. Division 1 proposal is a possibility, but I'm of the view that a less, I call it invasive step, rather than actually appointing a receiver, maybe to obtain relief from the court under Section 63 of the PPSA. When the PPSA came in 1981, most thought that Section 63 was there for a very limited purpose, but the courts in Saskatchewan were very elastic and the lawyers were creative, and Section 63 was used for many broader purposes. So a lot of the things that might need to be done for a successful realization or a successful reorganization could actually come, in my view, with a proper application and the assistance of the court under Section 63 of the PPSA. So with those comments, I'll turn it back over to Madam Justice Jackson.
So those were three very interesting presentations, and in the course of our conversations, just to explain to the persons who are watching, we have been talking about several matters. So I think what I will do is maybe lead off with some questions, and hopefully they will prompt questions from our audience. One question that came to me this morning as I was preparing was that, given the specialized nature of this work, how did each of you come to be involved in it? Did you have a mentor? Did one thing lead to another? And maybe we'll start with you first, Mike, as you were the last speaker and spoke last on the previous part.
Thank you, Justice Jackson. So I graduated from the College of Law in 1980 and articled at what was then McDougall Ready Wakeling. And it was at that time the PPSA came into force, May 1, 1981. That law firm had been around just about 100 years, but the problem was nobody had graduated in the last 5. So nobody knew anything about the PPSA, even though we were a banking law firm. So I ended up doing a lot of lending, which then led to realization work through the farm crisis of the 1980s and then on to other things. So that's how I ended up doing what I'm doing.
Ms. Lavoie-Harding, how did you establish your interest, expertise in the area?
Thank you, Justice Jackson. I articled at Robertson Stromberg, and I had the privilege of learning the ropes, so to speak, from Kim Anderson. And he is an excellent lawyer who is a very practical lawyer in this area of the law. So I got exposed to this area of the law through him, and I was lucky enough to learn from him. I then had the privilege of working with Jeff Lee at MLT, and for many years I learned this area of the law and worked extensively with him. And so again, I had the privilege of having a mentor to learn from. And then coming to McKercher, I also had the privilege of working with Joel Heshey. So for me, I think I gravitated towards this area, one, because it is practical and it makes sense to me, and I enjoy the working relationships I have with my colleagues around Saskatchewan in this area, which it's always enjoyable to work on files with them. So I had the opportunity to learn from very good lawyers in this province, in this area of law, and so that is the reason why I continue to practice in this area.
Mr. Lee?
Yes, thank you, Justice Jackson. I graduated in 1987 and came into this area largely due to circumstance and fortune. Mike mentioned the farming crisis of the 1980s. That was at the height of it, pretty much the time the Saskatchewan Farm Security Act in its present form was introduced. So that we had client needs at the McPherson Leslie Retirement Firm in this area. I had a mentor who taught me the area, a senior commercial lawyer, Carl Wagner, who was a great person to learn from, a great teacher. And what I enjoyed about the practice area was it combined aspects of litigation and court work on the one hand, and solicitor work, drafting and solving problems on the other hand. And it's unique in that way, in my way of thinking.
Okay, thank you for that. So a particular question for you, Mr. Lee, comes up with respect to the templates. You mentioned the Queen's Bench Bar Association templates. Could you expand a bit on that? What role do they play? Are they
Sure.
like precedents that you must follow? Just to, and maybe start with a very basic question. How does one find the templates?
Thank you. Yes, so these template orders reside or are domiciled on a portion of the Court of Queen's Bench for Saskatchewan website. Saskatchewan Law Courts, the Queen's Bench portion of that, there's a section for administrative notices, and there are 5 or 6 template orders housed there. We have a template order for most plays in the insolvency playbook these days. There's an initial order under the CCAA. There's a template receivership order. From there, more specialized or unique orders addressing unique circumstances are included. One of the most common is a sale approval and vesting order, where the court is asked to approve a sale transaction, or a distribution and discharge order, where the court is asked to approve a discharge of the court officer and authorize distribution of sale proceeds. So these orders, it's quite clear, do not have the force of law, but they do have the force of experience and consensus, which is perhaps in some circumstances just as powerful. They are the starting point in most cases. Departures from the template orders are typically identified by the red line function comparing a particular proposed order against the template. And they've been around about 15 years. They've been developed and updated by a committee of practitioners and by the insolvency panel of the court. And they've served to streamline and make the practice more efficient and cost effective. So that they're very significant despite not having the force of law behind them.
Thank you, Mr. Lee. So both for Mr. Milani and Ms. Lavoie-Harding, it's obvious that consensus is a pretty important aspect of this area of the law. And perhaps you could talk to us about building consensus. Does consensus depend on the choice of procedure? Are some procedures easier to sell to the other side than others? I noticed in each of your slides, by and large, you ended up with the same list of options. How do you then take the matter to the next step to get consensus on one of those options? Maybe Mr. Milani?
Sure, thank you. So in the first instance, it's ensuring that your own client understands the options. And sometimes that's pushing water uphill if there's been a lack of trust. But typically, we're able to assist the lender in coming to its own realization that all options should be considered, even briefly, so that the best and most creative choice can be made. Then the second step is on a without prejudice basis, having candid conversations with counsel opposite. The nice thing, one of the many nice things about practicing in Saskatchewan is that the bar is small and the level of trust among counsel is high. And so usually there aren't preconceived notions, there are choices, and we work collaboratively to find the best choice.
And would you have something to add there, Ms. Lavoie-Harding?
No, I think what Mike said is bang on. In terms of representing the debtor, sometimes the most difficult part of representing the debtor is understanding the circumstances and having those frank discussions with your client as to the realities of what they are facing. In a lot of these situations, and particularly with small businesses, the individuals in these small businesses have worked very hard at these business. There's blood, sweat, and tears are in these business. And so one of the hurdles is getting them to a situation where we can discuss practical options. It may not be the best option in their eyes, but in terms of if they want to come out of this with a viable business, there are certain decisions that will have to be made. And so from my perspective, I think that is the most difficult or challenging piece to it when advising debtors.
That's very helpful. And perhaps picking up on that, and I will just mention to the audience that we are all students of Professor Ron Cumming. So he's had a significant influence and impact on our lives. Indeed, he was instrumental in bringing together this panel today. Unfortunately, he couldn't, personal matters kept him from participating or watching today, but he asked a particular question of the panelists that I'm just now going to read to you just to make sure I have his exact words. So his interest was how secured creditors fare in one or the other of the various insolvency proceedings. So, for example, would a secured creditor be better off, to use that colloquial expression, or a much diminished security position in the insolvency legislation, the CCAA and the BIA, as opposed to the provincial legislation, the PPSA? Is the secured creditor's position diminished by the choice of procedure, the choice of platform? So perhaps, Mr. Lee, we haven't heard from you for a few moments. Would you like to start on that?
Sure, thank you. I think a lot would depend on the type of the security held and the complexity of the business or the borrower. If we're dealing with a relatively simple secured debt arrangement on specific items of personal property collateral, or perhaps security in bare farmland, in those circumstances, relatively simple arrangement. There's no particular need to have an ongoing business in place to support the value of those assets. And then I think for the most part, the secured creditor would prefer to be outside these complex insolvency regimes and just enforcing its security under provincial law. Where the security is more complicated and requires a viable operating business behind it to preserve enterprise value, collect accounts receivable, that sort of thing, then I think in that scenario, secured creditors would typically prefer to be inside a formal process where the enterprise value can be preserved and the value of their security in turn is preserved.
Excellent. Mr. Milani, do you have something to add?
Only that I agree.
And Ms. Lavoie-Harding?
Similarly, I agree.
Okay, so we have some questions from the chat area, and I will just read those to you. So in the scenario presented, if the shop remains operational, is there any obligation on the sole supplier to continue supplying jeans, even if payments are in arrears? In essence, to keep the shop operational. Who would like to tackle that?
Maybe I can touch on it, and then I think Jeff would have something to add on the macro level. There is a concept known as a critical supplier, where sometimes a court by order will direct that supply continue. But in those circumstances, the supplier is entitled to be paid for or secured for future supply. So the answer is it's theoretically possible, unlikely in a scenario like this. Jeff, would you agree?
I think I would. Maybe the exception might be if the debtor moved along in the process and invoked a formal restructuring regime, and if this supply arrangement was not merely a handshake or a series of purchase orders, but was a specific written supply obligation, then I think an insolvency filing could potentially require continued supply, but only on a cash basis. Many of these contracts have insolvency clauses that say if you become insolvent, I can terminate immediately. And suppliers often think, well, that's my answer, only to find out that, well, not so fast. The whole point of these insolvency regimes is to stop the operation of those clauses.
Ms. Lavoie-Harding, any thoughts on that?
Oh, and I think that covers it.
Okay. So there is a question in the chat area about COVID-19. And maybe I will just build on that question to ask you this. Are you already in your day-to-day practices seeing an uptake in concern from businesses, lenders about the impact, or the potential impact, the actual impact or the potential impact of COVID-19 on the financial health of Saskatchewan companies? Maybe Mr. Lee, for you first, please.
I would say that COVID-19 concerns and consequences have increased activity levels over the last 6 to 8 months. But having said that, I think it's fair to say most expect a much greater activity level yet to come. Evidence of that includes chartered banks in Canada having set aside north of $10 or $15 billion to deal with loan losses that are anticipated, and massively staffing up their special loans groups. So activity levels have increased, but I think there's an expectation they will significantly increase more in the time ahead.
Any thoughts that either Mr. Milani or Ms. Lavoie-Harding would like to add?
Just one small piece, and what we're seeing a lot of is reorganization of debt and restatement of credit agreements. And so it's not quite at the realization stage yet, but the lenders and borrowers are trying to find measures to either delay that or hopefully preclude that.
Ms. Lavoie-Harding?
I would agree with that. We are seeing increased activity. There is, at this point in time, when acting for lenders in my practice, a willingness to entertain workout agreements that cover, going forward 3 to 6 months. And so we are seeing increased activity now, but I agree with Jeff. It is anticipated that it will become more active in the next, in coming 2021.
So related to the question of COVID-19 in terms of anticipated increases, have there been any changes with respect to the limitation periods that have affected you in your work? Perhaps if one of you would like to talk about the federal legislation dealing with limitation periods, or the provincial legislation or rules of court. Any thoughts you'd like to share with the audience?
I'll just mention one point, Justice Jackson. Typically in a forbearance agreement, we will provide for lender and borrower agreeing to extend the limitation period as permitted under the Limitations Act, because having to move too quickly because of a limitation period is not usually consistent with the best business decision.
I might just add to that in the Bankruptcy Insolvency Act, both in the commercial context, but more of more concern perhaps in the consumer context, there are certain time limitations which must be met and adhered to, failing which certain undesirable consequences ensue, such as bankruptcy. So in the spring, the Office of the Superintendent of Bankruptcy was party to court applications in each jurisdiction to suspend the running of those limitation periods, and that happened in Saskatchewan as well. So there are orders in place that relieve against those time limitations in pretty much every province.
Yes, I was just going to discuss what Jeff discussed about those orders that were rendered in the provinces.
You may be on mute, Justice Jackson.
Thank you, Mr. Milani. From the chat area, what are your thoughts on obtaining accurate information from CRA in respect of the CRA liabilities, particularly in COVID times? Who would like to tackle that? How have you found it? Has your business relationship changed with CRA because of COVID? Anything that you could offer to the person who's asked that question? Do I have a volunteer?
I would just note that for a period of time, CRA personnel were out of the office and not available. We've seen that start to change now as they've come back to work. But the challenge in the area is that there are no registries that people can search to obtain data on CRA debts or liabilities. So even the fact that people are back at work won't really help in that regard. CRA does have certain insolvency specialists who can assist. And we've had decent results engaging directly with those people by way of telephone inquiry in certain types of formal restructuring proceedings. But that's only after a formal proceeding has commenced. If you're simply contemplating one, I'm not aware of any particular way to get that data out.
Okay. And maybe if that person has further information that would shed some light on the specific question, perhaps they could pass that on to Professor Keat, and then she can see whether or not there's some follow-up to the particular question that would help get the answer that's required. So I think that we're just about wrapping matters up. I wanted to reiterate that our three panelists today have brought considerable expertise to this session today. They have explained the framework. They have put their work in context. They show how important negotiation and collaboration can be, not simply in areas of non-commercial consequence. It's clear that negotiation and collaboration in the commercial context is as important in this area of the law as it is in others. I note in the chat area that there's a comment about finding ways to provide for unpaid mentorships in this area. So I'm sure that particular question reflects is the tip of much more interest that could occur in this area. I want to offer my thanks to Professor Cumming as well as to your three panelists. And I'll turn the matter back over to you, Professor Keat.
I just wanted to join you, Justice Jackson, in thanking these wonderful panelists, Mike, Jeff, Janine, for their time, for your leadership too, Justice Jackson, and as you mentioned in the background, for Professor Cummings' endless, tireless work in this area. It's an important topic and very timely, and we're grateful that so many people were able to join us in this online event. So thank you to everyone, and keep an eye out for our future lecture series events, and I wish everyone the best. Have a good afternoon.